As promised, a Q&A section with me, your black belt barrister, helping you to understand law, but we are on Black Belt Secrets, where you can share the secrets of the life of the black belt barrister. So please make sure you subscribe here because this is a different channel, but I've had lots of interesting questions from you guys on here, so let's go through some of them. The first one that popped up from Jane Dixon was not a question, but I'm going to read it out anyway because I thank you for it. It says, "Thank you for your informative, entertaining and wise videos. Love watching them as they put a sensible view of things in context. Keep up the good work." I certainly will, Jane. Thank you for your comment and thank you for watching. Monad asks, which case of yours haunts you the most, if any? i.e. an outcome that you thought was completely unfair. So, Monad, you're going with the angle, which one was completely unfair? And your first part of the question, which case haunts me the most? Well, there's two questions in there. Being the lawyer, I'm going to answer both and probably in reverse order. One case that I thought was completely unfair was a road traffic collision where it was established quite clearly that the other driver had entered the road at a high speed and crashed into my client's vehicle. But for some very obscure reasons, the judge came to a conclusion that it wasn't unreasonable in the way that they were driving, and that simply because my client hadn't taken a second glance after entering the road, having been clear and safe in the first place, then the judge held my client at fault, which frankly I thought was a bit unfair. I can understand the reasoning, but I just felt that was unfair. As for which case haunts me the most, well, I was only instructed on this case for a very short period of time, but it still comes back nonetheless. It was a case under the Children Act of 1989. Essentially, parents were arguing about custody of the children, and there was an issue as to who caused injuries to the child. Essentially, each parent was blaming the other, but there were quite clearly very severe injuries to this child. And through a period of analysis, it couldn't have been anybody else because the child was in the care of one parent or another. But the injuries were noticed by somebody and therefore investigated and reported and so on. But the dispute in the case was ultimately which parent caused the injuries, because of course, whichever parent caused the injuries should not be the parent that that child should live with. But without going into detail, that's one case that does come back to haunt me. Monkeypox, real name Alan McCabe, has two questions. First of all, how do I have the time to make so many videos each day whilst representing clients? Well, they don't take very long to produce. Unlike most YouTubers, I suspect, spend days and weeks editing together their videos. You probably gather that I just hit record on most of these. I don't really plan them. I don't really need to research them. I do, I suppose, read the law beforehand, which again doesn't take very long, but it's usually something I know about. For example, you could ask me about knife law and I can tell you all about it without having to go and read anything about it beforehand. So for the most part, I just hit record. And the other reason is I'm up early and I go to bed late. So I have as many hours in the day as one possibly could. The second question is, would I or Al consider becoming a judge in the future? I've thought about it for a long time. My conclusion is probably not, although I'd never rule it out. It's something that I would find interesting, no doubt, but I think there would be limitations with becoming a judge, which I probably wouldn't want to live with. I'm an entrepreneur at heart, I'm kind of a free spirit at heart, and I don't think that goes hand in hand with being a judge. So probably not, but never rule it out.
Would I consider becoming a judge? Well, in some respects, I have considered it in that I have been to the sort of various meetings and seminars they have about this, although admittedly that's usually just because there's free food. But no, it's a very different skill set. It's all about sort of being the umpire, being the manager, being the referee, which is a very, very different thing from advocacy. It's interesting that in some jurisdictions like France, being a judge is a completely different career path. So in the same way that people will do their sort of law degree and then go off and go to lawyer school, in France they will do their law degree and then go off to judge school, which is why their judges tend to be quite young. But they do recognise that it's not quite the same thing as advocacy. Although then again, that's a different system over there, which we'll have to talk about one day.
Chris Thompson asks, what English laws are Americans or other visitors most likely to break unintentionally, or which laws do visitors or tourists seem to be surprised by? That seems to me to be knife laws and other laws regarding what are generally considered to be weapons, because they are very, very strict in the United Kingdom. And otherwise, perhaps medicines and this kind of thing, because again, we have very strict limits on certain types of medicinal drugs, which might otherwise be normal elsewhere, would be prescription only here, and have fairly severe laws surrounding them. So those are probably some laws that would unintentionally be broken or certainly be surprised by. For instance, in the United Kingdom, it is an offence under Section 139 of the Criminal Justice Act 1988 to be in a public place with a blade without a good reason, except for the exception, which is a folding pocket knife, which is something that does not exceed 3 inches in length of the blade. It does not lock. It's immediately foldable at all times and doesn't have any kind of slogans on it like harm and things like that. This is a Spyderco knife, not a sponsored video, although sponsorship's welcome because I do like these little things. And I do like to go on the fray, on the very edge of what is absolutely legal. So if you wanted to carry something around that is legal, this would be it. Not that I recommend it, because I don't think there's a need really to carry a knife around, and it depends on what you're doing. But that's certainly something that most international viewers of my channel find quite interesting and quite surprising. Tammy asks a fantastic question and would love to know my top 5 favorite dishes from Easy Chinese Cooking and why. Easy Chinese Cooking, by the way, is my dear wife in the next room, and if you're not subscribed, you really should be. It's linked in every single video that I've released, so make sure you subscribe. Now, I honestly couldn't choose just 5, but I suppose I can tell you 5. The rice dishes are amazing. The wonton is amazing. The noodle dishes are amazing. The egg and tomato is amazing. And I suppose the traditional Sichuan spicy chicken with sesame seeds. Check those out. I will try to link as many of those as I remember to do so in the description below. Next question from Melissa Dunkling. Why can't or couldn't TMZ be forced to release who sold the Depp cabinet video, since it was clearly taken in his home without permission, etc., etc.? Well, essentially, they own the copyright, and that is very distinct from who gave it to them in the first place. And for the court to order them to disclose who gave them the video would require a very good reason as to why they should disclose that. So, for example, if there was a severe murder and it was going to be very clear as to who did it by disclosing the name of the party, then because it's linked to a crime, that might be much more likely for the court to order that. But just who gave them the video, it doesn't really go to any issue that the court's likely to make that order. Danny Dawson's been watching my videos, so thank you very much, and is interested in the legal details and was wondering what my opinion is on the IPP sentence. I presume you're talking about the imprisonment for public protection. Well, an imprisonment for public protection is exactly what it sounds. It's imprisoning somebody to protect the public and to protect other people. So in that sense, I think as a society, we do need to have that in place, but we do need to be right about it. And so when that's made, there are the usual protocols to make sure that it's right and the usual appeals process and so on. Question from KME. Where do you see the legal system headed within the next 5 to 10 years? Do you think any of the supposed judicial reforms will stand a legal test if it was brought? Well, I think the legal system in the next 5 to 10 years is going to get a lot more simplified in terms of smaller or similar or streamlined cases, simply because the court system needs to be able to handle a higher number of cases, because it's only going up. Now, the backlog is getting longer, and so there needs to be a much more streamlined way of handling these cases. So maybe with AI, maybe, and I would like to see with some lawyers or even paralegals or so on, having some kind of hand in filtration of cases so that it doesn't waste court's time. Because if a case is so clear, it could at least be filtered to a judge to just go through a checkbox exercise to dispense with those cases if they are totally unmeritorious. There is a system in place at the moment to strike out a case if there's no merit, but that still warrants a judge's time, court time, and it's still open to all of the same set-aside applications and so on and so forth. So invariably they chew up a lot of court time, and I think that's the biggest drain at the moment. So that is where at least I would like to see it going in the next 5 to 10 years, to streamline cases, to get through cases a lot quicker and more efficiently. Amber asks, if you hadn't gone into law, what would your alternative life look like? Well, actually, I didn't go into law to begin with. I've been in business all of my life, and I've done lots of different kinds of businesses. So in fact, my life hasn't really been law, at least not for most of it. So I've been in all sorts of different businesses, and one of those has been a barrister's chambers and a law firm and being a barrister. So actually, I've done lots of different things, so not just law. Coco Bean asks, what do you look for when determining whether or not to take on a client? Well, first of all, if they're instructed by a solicitor, because then I'm caught by the cab rank rule, because if I'm available, it's a proper fee and it's of my level of competence, then I have to take the case without any kind of prejudice whatsoever because of the cab rank rule. So we have to take that case on if those things are met. So that's the first thing to consider. If it's not a solicitor, but it's public access, then I'm required to consider whether the client, the lay client, can fulfill the role of a solicitor, which is handling all the correspondence, dealing with all of the court applications, unless they're instructing me to do the litigation. But not many barristers do litigation, although I do. And throughout all of those instances, I must also check for any conflicts of interest. So before accepting any case, we do a conflict of interest check, and that's essentially to see whether we've represented the other party or we have any kind of conflict whatsoever, in which case we cannot take the case. There's a whole list of other rules which I won't go into, but there are lots of rules that we must look at and consider before taking on a client. I appreciate this might be a little different to other jurisdictions where they can pick and choose whether or not to take on a client or not, but certainly here we are under fairly strict rules about taking on a client. Interesting question here from Sarah Gardner, who has a World War II ammunition bunker on the land, and asks, would she need any type of planning permission to build a timber roof on top of it, as it currently leaks, with a small storage room inside it? Now, usually, it always depends on the local authority, because each local authority implement the main planning legislation, but in their own particular way. Ordinarily, without buildings like that, you probably wouldn't need permission, unless, of course, it's a conservation area or right next to the boundary or something like that. In most cases, you're probably fine, but in all cases, I would certainly check with the local authorities' planning guide whether they say that you should have permission or not. If in any doubt, you could always seek a certificate of lawfulness from the local authority without necessarily getting full planning permission. So, as I said, I would always check. Christy asks whether it's normal for the police to send a victim home to write their own statement instead of questioning them. Well, a statement is exactly what it sounds like. It's a statement by the person, signed by the person. It doesn't have to be done by the police or in the presence of the police. Ultimately, they are signing it to say that it's true and accurate, and that's what counts. Baxter asks about freedom of information requests. How in the UK would you go about getting the trial documents for a murder case? Contact the court office. They can arrange any documents that are publicly available, save for those, of course, that are restricted, which is not usually that many. Justin asks where he can find in the UK judge's statement about giving Amber Heard credibility because she donated the money to the charity. Well, that was contained within the lower court judgment. I say the lower court, it's the high court. I say lower court because it went to the Court of Appeal. So you can find those just by Googling the judgment for Depp and News Group newspapers and Dan Wootton in the UK trial, and that should pop right up. It will be a PDF and it should be easy to find. Christy also asks, what does it mean when the police decide that a complaint is found to be unsubstantiated and refuse to investigate it further? Now, that doesn't necessarily mean it doesn't happen. It just means that they didn't find something to support the complaint, and therefore they didn't want to investigate further because they felt like they wouldn't reveal any further evidence, and so any investigation would probably be fruitless and they didn't find any evidence to support it, not necessarily to say it didn't happen, but couldn't find anything to support it, so didn't investigate it and didn't take it further. That's essentially all that means. LR Disco, if that is your real name, asks, would I ever plead guilty for a reduced sentence even though I was innocent? It's a really tough question, and I understand why you ask, and many people would be quick to say absolutely not, because, why would you ever plead guilty to something you didn't do? But that's a really tough question, because it would really depend, because if there were lots of evidence against somebody, even though that evidence might be wrong, and there was a high likelihood in a professional opinion that you're going to get convicted, even though the advice should strictly be to be pleading not guilty, if the evidence is overwhelming, even though it sounds odd because the evidence shouldn't be overwhelming if you didn't do it, but nonetheless, if that were the case, you would be faced with a very difficult choice, because a reduced sentence could be, let's say, even a conditional or even unconditional discharge, meaning you don't get fined, you don't go to prison, just don't do it again and don't do anything bad again, get out and get on your way. Even though you would still have a criminal record, which is quite devastating, particularly if you didn't do what they're accusing you of doing. So that is a really tough question. My gut response is, of course, to say absolutely not. I would plead not guilty all day, every day, because I didn't do it. But faced with the question, I think that is a really tough position to be in. So honestly, I don't know. It would have to depend on the circumstances. David asks, in a world of Photoshop and the ability to alter photo metadata, are photos admissible as evidence in court? Well, yes, absolutely, they are admissible as evidence in court. Although I have to say that the forensics teams are far better than most people give credit for when looking into photo metadata. So people that are thinking they'll get away with things by messing with metadata, think again. You might be surprised at how good they are. What size shoe do I wear? Well, that's an interesting question, because one of my feet is slightly smaller than the other. One of them's 10.5, the other one's 11. Please, can you talk about the Julian Assange case? I've done one video so far. Another question from Bobby Lad. Do I know the identity of the secret barrister? On Twitter. Well, not only on Twitter, of course, but no, I don't. A lot of people have said that it might be me, but it's not me. I can promise you it is not me. The books are fantastic. They are an excellent read. Check them out. I'll link those in the description if I remember to. If I don't remember, please remind me and I will do it afterwards. Some questions came about for divorce rulings and how long you can enforce them. Well, there was a recent Supreme Court decision in a financial case arising from a divorce from 1992. Now, in most cases, there is a strict limitation period to enforce a judgment, which is normally 6 years, the same amount of time it is for a contract. But in this case, the Wyatt case, the court made it clear that these rules and limitations do not apply in divorce cases. So those are the questions I picked out so far. Please keep them coming, and I might have to do many more videos on this. In the meantime, remember we're on Black Belt Secrets. Please make sure you subscribe, like the video, share it, hit the bell, comment below, all of that kind of stuff. And as always, thank you for watching.